Welcome. We are Mariela Vasconcelos and Maria Malvar, and our topic of conversation is student privacy. We will present and provide a brief historical data on the three main laws that protect confidentiality. While not explicitly stated in the U.S. Constitution, some amendments provide some protection. Privacy, a right or a privilege. The right to privacy refers to the concept that one's personal information is protected from public scrutiny. U.S. Justice Louis Brandeis called it the right to be left alone.
In our fast-moving technological world, we have to be very aware of student data and their privacy. So what constitutes student data? Well, it's as simple as attendance, grades, discipline records, and health records. As teachers and future administrators, we need to be aware that there are legal and ethical restrictions that impact the school districts, individual schools, and teachers. School districts have an obligation to protect the confidentiality of students' records. In today's technological world, many online companies offer services to schools that provide online access to student records. Before any contract is signed, said contracts must be thoroughly reviewed by the district school attorney in order to ensure compliance with the student's records law. In the next several slides, we will review the three main laws that protect said confidentiality. In this brief presentation, we will be talking about the three laws that are designed to protect our confidentiality. The first one being Family Educational Rights and Privacy Act, FERPA. Second one, Children's Online Privacy Protection Act, COPPA. And three, Children's Internet Protection Act, CIPA. The three laws were set forth by the Federal Communications Commission, the Department of Education, and the Federal Trade Commission. The Family Educational Rights and Privacy Act of 1974, or better known as FERPA, was signed into law by President Gerald Ford on August 21, 1974. FERPA is a federal law that protects the privacy of personally identifiable information from the student's educational record. This law also gives the parents the right to have access to their child's education records, the right to seek to have the records amended, and the right to have some control over disclosure of personally identifiable information from the education records. As we learned in the school law class, when a student turns 18 years old or enters a post-secondary institution at any age, the rights under this law transfer from parent to eligible student. This law also requires that information about the disseminated student information must be kept in the student's CUME. Children's Online Privacy Protection Act of 1998. The Children's Online Privacy Protection Act, COPPA, gives parents control over what information websites can collect from their kids. The COPPA rule puts additional protection in place and streamlines other procedures that companies covered by the rules need to follow. COPPA imposes certain requirements on operators of websites or online services directed to children under the age of 13 and on operators of other websites or online services that have actual knowledge that they are collecting personal information online from a child under the age of 13.
The Children's Internet Protection Act, (CIPA), was enacted by Congress in 2000 to address concerns about children's access to obscene or harmful content over the Internet. CIPA imposes certain requirements on schools or libraries that receive discounts for Internet access or Internet connections through the E-rate program, a program that makes certain communication services and products more affordable for eligible schools and libraries. In early 2001, the FCC issued rules implementing CIPA and provides provided updates to those rules in 2011. Schools and libraries subject to SEPA are required to adopt and implement an Internet safety policy addressing access by minors to inappropriate matter on the Internet, the safety and security of minors when using electronic mail, chat rooms, and other forms of direct electronic communications, unauthorized access, including so-called hacking and other unlawful activities by minors online, unauthorized disclosure, use, and dissemination of personal information regarding minors, and measures restricting minors' access to materials harmful to them. Schools and libraries must certify they are in compliance with SEPA before they can receive E-rate funding. SEPA does not apply to schools and libraries receiving discounts only for telecommunications service only. An authorized person may disable the blocking or filtering measured during use by an adult to enable access for bona fide research or other lawful purposes. SEPA does not require the tracking of Internet used by minors or adults. We need to remember that FERPA, COPPA, and SEPA seek to monitor and protect students in schools and in the commercial marketplace.
We thank you for viewing our presentation and we hope you have enjoyed it.